Thank you very much. Thanks also to the organizers for inviting me. I think it's the first time that I present something in EUI after my PhD defense, so I'm really, really happy to be back. I always seek for good reasons to come back. Of course, my topic could have been a bit more cheering, but one can have it all. Actually, we were with Bruno in another conference like 2 weeks ago, and there was another participant from Spain, Violeta Ruiz, who is also a participant in this conference, and said that sometimes the contributions of Southern Europeans to conference on crisis, they sound a bit like Alcoholic Anonymous. What happened to us? We used to be so nice, but now, you know. So I'll try to avoid this kind of victimization. But before I start with my paper, let me make a small caveat. This paper is not a catch-all paper. It's not my political opinion on the Greek crisis. It is a rather modest attempt to understand the tensions between the implementation of this financial program with the Greek constitutional order. And actually, although I am from Greece, it's the first time that I'm dealing with Greek law, and the cue that I got in order to actually research the subject had very much to do with a debate that takes place for the last 3 years in Greece. And it's a debate about exactly how much this financial program is influencing, is impeding on the Greek sovereignty. And it's a debate that almost everybody participates. And when I say everybody, I mean the political parties, the different academics, epistemic communities like the constitutional lawyers, the Athens Bar, even the Church of Greece. The Church of Greece has actually had its views on how much sovereignty has been influenced for that. And of course, last but not least, the people. The people that, as we heard this morning, make the life difficult of Dr. Zilioulis' colleagues. So, as we see in this picture. And the opinions that you will hear in a debate like that could not be more diverse. So you have, in order to give you an example, you have people like Professor Douzinas in Birkbeck College in London, who has said that Greece has become a colony. You have an emeritus professor of constitutional law of the University of Athens, Professor Kassimatis, who has said that actually because of this financial program, we may lose the ownership of our embassies abroad. So in the way that you would lose your property of your home, you can be evicted in case you don't honor your debts. And then you will have other people like the vice president of the ex-vice president of the government, who said, actually, I'm very happy that we lost our sovereignty, not least because what we have created until now was a totally failed state. So it's good to give the keys to the international community. At least they know how to build a better state. We have totally failed. Now, one might say that this is a bit the over-emotional reactions of a nation. However, one has to admit that the debate about sovereignty, the crisis, democracy, is a debate that goes beyond the borders of Greece. And that's why I'm referring here to 2 extracts from Bloomberg and the Financial Times. The same week, in February of 2012, one speaks about sovereignty and the other speaks about democracy. So it's not only the Greeks, but generally speaking, there is a question about that. Now, my research, what I want to assess is exactly those arguments, and in a way to understand what kind of tensions have this financial assistance package has created to the Greek constitutional order. And from the outset, what I can tell you is that I think I have showed in my paper exactly how much the implementation of the financial assistance package has taken place in breach of the Constitution. However, and contrary to the conventional wisdom that exists in Greece, this is not a critique against the bad Germans or the IMF or the EU. It's mainly a critique about how this political system has worked. So they did it in a bad way. Now, in order to do that, I mainly will focus on point 2 and point 3. So mainly what I want to see is exactly how this financial assistance package has been implemented, and then I will show exactly this kind of breaches to the Constitution, and then try to see whether those breaches can be justified according to the doctrine of necessity, as it has been claimed. I'm not going to speak about the fiscal compact, because there are other people that will speak about that in this conference. Plus, Greece is not by any means exceptional when it comes to the application of the fiscal compact. In order to start, though, I want to just spend a couple of minutes to give you to understand what I mean when I speak about popular sovereignty. In my paper, I go to much more detail, but what suffices to say at the moment is that I use the lowest common denominator. Actually, what I'm doing is I try to distinguish between external sovereignty and internal sovereignty. I say that external sovereignty is the state's power to act independently from an external higher authority. In that sense, in this particular case, Greece was facing an existential crisis. The Greek government had a number of options to choose from in order to deal with this crisis, and sovereignly decided to seek for financial assistance, signed those agreements, and that's the way they dealt with the crisis. So, to my mind, from an external sovereignty point of view, the implementation of the financial assistance package doesn't raise any significant questions. Now, there is the other thing which has to do with the internal sovereignty, which means the ultimate source of authority within a state. And there, Greece has actually opted for a popular sovereignty model. What it means is that the people, according to the Greek constitution, represent the ultimate source of authority. In other words, what I'm claiming is that the most important declaration of popular sovereignty in Greece is the constitution making itself, the drafting of the Greek constitution, which actually refers in at least two cases, in two articles, to the foundational position of popular sovereignty within this constitutional order. So what I'm claiming actually is that to the extent that this financial assistance package has been implemented in breach to this constitution, that raises questions from a popular sovereignty point of view. Now, I'm not going as far as saying that whatever is the constitutional breach, it means that the popular sovereignty has gone away. But we can assess what kind of constitutional breach have been committed and also the extent of the threat to the popular sovereignty. So, going now to the financial assistance package, going a bit to a history trip back to 2010. Now, the first financial package for Greece was materialized through three distinguished, different pieces instruments. The first is what we heard before, this memorandum of understanding. This is very much a political agreement. It's a political agreement between Greece, on the one hand, and the EU, on the other hand. In this political agreement, what actually they say is that all the parties admit the problems that exist in this particular polity, in this particular economy. Greece commits itself to a certain financial program, and then the EU commits itself to provide for the financial assistance to this program. Then we have this standby agreement with the IMF. This, according to the IMF, is a soft law instrument. Although it has provided 30 billion euros to Greece, it's still, according to the IMF, a soft law instrument. And then we have what Bruno referred to before, these bilateral agreements with the different member states, that's 17 member states, that provided for those loans, for this 80 billion. So we have this overarching loan facility agreement, which actually provides for this system of pooled bilateral loans, by which we got financed with 80 billion euros. So, one political agreement, one soft law instrument, and one international agreement. What you have to know about the Greek constitution is that it's a dualist system. What does that mean? It means that in order to have a certain international agreement ratified in the Greek legal order, it must be ratified through the parliament. And there are two different procedures, Article 28 and Article 36. I'm not going to spend any time, just to have in mind that if you have an international agreement, it has to be ratified. Going back to the three instruments, and starting from the first instrument, which is the Memorandum of Understanding. As I said, this is a political agreement, and I explained what exactly is there. It's the financing and the conditionality. The Greek state thought that in order to implement it, it has to actually issue a law. And this is Law 3845/2010, to which I refer in the very start of my slide, that they issued on 3rd May 2010. And this law, although it actually adopts this financial program, at the same time, it recognizes that if there is a bilateral, if there is an international agreement, and this you can see it with the red section, this has to be ratified through the parliament. Now, the Athens Bar, and I'm going back to what I said about the debate taking place at the moment in Greece, actually challenged that in front of the highest administrative court and said that actually the Memorandum of Understanding is not just a political agreement. It is an international agreement, and a law of the state is not enough to materialize it. It had to be ratified under Article 28 or 36, to which I referred before. I'm not going to go into much detail, but suffice to say at the moment that STE, this is the highest administrative court in Greece, said that it's not an international agreement, it's just a political agreement, and a law is just enough, it's just fine. But the Athens Bar also challenged the substance of this financial assistance package, said that those measures are extremely severe to such an extent that they actually go against, they breach the right of property according to the European Convention of Human Rights in Article 1 of Protocol number 1. And there, the highest administrative court said actually that in this kind of emergency situation, the margin of appreciation of the legislature is wide enough to justify even such severe matters, such severe cuts. So it's not a violation of the property rights according to the convention. Now, interestingly enough, 3 years down the line, things start to change. The European Committee of Social Rights 2 months ago had 2 recent decisions finding that those measures, some of those measures, very particular measures, are against the European Social Charter, but also the Greek Court of Audit actually said that certain decisions, certain financial cuts actually go against the protection of human dignity, which to the German lawyers among you, it will be a very familiar tone. What is interesting to note is that the highest administrative court said that this decision does not actually breach Article 1, but at the same time, it provides some limits to what the legislature can do. And those limits could be described according to the principle of proportionality. So any decision, any financial cuts should be proportional. So case closed here. It's a political agreement. The highest administrative court said that everything was fine. Let's go on. Then you have this standby arrangement with the IMF. As I said, it's a soft law instrument. So again, there was no need for ratification. Now, final point, the loan facility agreement. Now, this is clear that it's an international law agreement, and this is something that the administrative court has accepted. However, we are now in 2012, 2 years and a half after the signing of this agreement, and still the Parliament has not ratified this agreement. And this is the first breach to the Constitution. You have a very important international agreement that has not been ratified 2 years afterwards. What is more, after the signing of this agreement, we have a new law which actually provides that this kind of agreements that they want to materialize the financial assistance packages, like this loan facility agreement, and this is the second bullet point, they don't have to be brought to the Parliament for ratification anymore. They have to be brought to the Parliament just for discussion. And that they are deemed ratified at the moment that all contracting parties sign them. So in a way, by virtue of this law, of these laws actually, because the second law has to do with the second memorandum, the Parliament actually amended the ratification procedures that are prescribed in the Greek Constitution. According to this law, for those particular agreements, for these very special international agreements, ratification procedures either under Article 28 or under Article 36, are not necessary anymore. They are deemed ratified when all the other partners sign them. So for me, there are two major constitutional breaches. The first one has to do with the fact that the first loan facility agreement has not been yet ratified, and the second has to do with this particular law that amends the Constitution without using the constitutional procedure. Now, the thing is that the Greek political elites are not unaware of this, and they have been actually challenged by certain people that they said that the parliament has actually acted in an unconstitutional way. And actually, the justification is not that we actually have acted in accordance with the Constitution, but they have adopted another kind of discourse saying that the highest law is actually the savior of the country, or that the default of the country, and this is last week's statement in the parliament from a minister, the default of the country will consist of the gravest breach of the Constitution. So in other words, what they're saying is that, okay, yes, maybe here and there have been some problems with regard to the constitutionality, but it's too much of a high stake. The bankruptcy of the country is a legitimate aim, it's a legitimate purpose that can justify this kind of unconstitutional acts. Now, if we translate that to constitutional law terms, this is pretty much what I refer to the doctrine of necessity. And this doctrine, according to this doctrine, certain actions of the government might be justifying, even if they are unconstitutional, if it can be proved that they are taken in an emergency situation and they are intending to secure the existence of the state. And it's a doctrine that exists in certain constitutional orders, mainly a doctrine that exists in post-conflict constitutional orders, but also exists in Greece. So we have this decision of 1945, which says that actually a government can actually act, even in deviation from the constitutions, in matters related to the primary purpose for which they were called to govern, namely the restoration of law and order and public security. So actually the Greek courts have recognized this doctrine of necessity. They have recognized the right of a government to act unconstitutionally, but only in cases of restoration of law and order and public security, which is clearly not the case here. What is more, you have to know is that this particular case is a case from the times of the Civil War. And it's not good precedent from a political correctness point of view. However, from a legal point of view, what I want to point out is that this doctrine of necessity exists in this constitutional legal order. However, it is very limited. Now, in order to be fair with the government and with the political establishment, I try to find a broader understanding, a broader notion of the doctrine of necessity, a notion that actually would go beyond just this restoration of law and order. And this can be found in Cyprus. There is this famous case of Mustafa Ibrahim, which have been actually verified, scrutinized and verified in the European Court of Human Rights, in Aziz against Cyprus. And it's important because actually in this particular case, we have a broader understanding of this doctrine. So again, it's unconstitutional actions. It can be justified when there is an imperative and inevitable necessity or exceptional circumstance. The bankruptcy of Greece can definitely go under this definition. There is no other remedy, and the measure taken must be proportional to the necessity. What I would argue is that there is no other remedy is highly questionable, not because the other remedies that we had were better. Staying in Europe, to my mind, is the better option. However, there were other remedies. Also, the last thing, which has to do with the temporary character, this is debatable because everything is temporary, but everything is permanent as well. I mean, 3 years now, all the measures are they start as temporary, but now they are almost permanent. So, in order to conclude this part, I would say that even under this broader notion of the doctrine of necessity, again, those unconstitutional actions of the government are not justified. To finish and to conclude, there is no doubt that the Greek government and all the Greek governments during those last 3 years, they have acted in order to manage an emergent situation. And we're talking about an unprecedented crisis, an existential crisis of the Greek state. And in that sense, I think we can understand a certain logic that would dictate an approach that would not be in accordance with the strict black letter understanding of the Constitution. However, to my understanding, the way that the system has worked, the whole Greek legal system has worked, in this particular case, is exemplary for how the rule of law is applied in Greece. We are talking about a constitutional system where it's executive-driven, and the checks and balances are very, very weak. What is more is that by questioning even this very weak rule of law application, I believe that this creates a rather dangerous precedent for a political system that at the moment is under threat from political parties that they have adopted a totally unconstitutional discourse, and I refer here to Golden Dawn. So although this is a very special case, I really believe that it's an exemplary case of how this constitutional system works. Thank you very much.
Thank you very much.